Hey, greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Want to remind everybody, hit that like, share, and subscribe button. There's a PayPal link down there for anybody that wants to share some love. Always appreciated. Was reviewing a video that I'm going to do a stream on later, and I came across a section that I wanted to put out to show you that these attorneys are just using templates, copy pasting, and trying to use them as a broad scope application across the board. And they're going to get caught like they got caught here. They're going to get caught, that these people do not know what they're doing. They're just copy pasting shit and hoping it flies. It's a lot like I explained about my situation 9 years ago, that I was just throwing things at the wall and hoping something would stick. And these guys working together as an authoritative cooperation, they stick because that's their job. So let's pay attention to this short little section of this video explaining how they don't read the information they're given. And it goes to show that the prosecuting attorney is not doing the proper pre-investigation before bringing charges.
Well, let me ask you something. I think you just said that it was included in the defendant's objection below. Are you talking about the 19-page objection that they filed to the request for the gag order?
Yeah, I think they mentioned.
So how quick, and you said that because it was included, it's fair to assume that the circuit court considered that and rejected that. Is that a fair assessment of your argument on that point?
I think you can assume that.
Okay, so let me ask.
I think you can assume that 19 pages considered. And notice he asked in the question about how long it takes to read 19 pages and how they get caught.
How quickly do you read?
As quickly as I can, Your Honor.
If you had to guess, how many pages per minute do you think you read?
If I'm reading carefully, a page a minute, probably.
So if the defendant in this case filed a 19-page objection, and 6 minutes after that was uploaded to the system, after the clerk accepted it and uploaded it to the system, the circuit court, 6 minutes, the circuit court filed the answer with multiple handwritten interlineations in the order, excuse me. Do you think that we can fairly assume that in those 6 minutes, from the time the 19-page objection went live until the time the circuit court filed her order, that she read, considered, and gave due weight to the defendant's objection in this case?
So in other words, they took a 19-page motion of objection to a gag order. This is what they're doing. They're pushing gag orders in this particular situation as it relates to Aaron Spencer. I don't know if you guys are familiar with him yet, but Aaron Spencer was the gentleman down in Arkansas last year that caught a predator with his daughter. They arrested this predator, but released him with almost no supervision of any kind whatsoever. Come to find out, he was a prior sheriff in that town. And so they had favoritism. Well, upon the release, of course, the guy went back to get his daughter and actually had daughter in his possession driving down the road when the man confronted him about his daughter. And they're trying to silence it because the guy ended up killing him because the system won't do anything about it. And this again is in reference to people standing up for their children and how the system is abusing their children and not letting the system abuse their children. And yet, even when you do stand up, the system wants to turn around and placate that you're the guilty one, that you're a vigilante of some sort. When it's the system and all the people, the corrupt officials that are covering their own ass, that trust each other to cover each other's ass, when reality hits the fan. We have to stop this, folks.
First of all, I would reject the premise of the question. I don't think there's any evidence. They have alleged 6 minutes in their briefing. But all we have in the limited record before this court is the file stamps, and the file stamps.
Yeah, all we have in the record, court's record at this time is file stamps. And the file stamp says 6 minutes after it was received, they issued the gag order. Or dismissed his motion, excuse me. 6 minutes after it was received. 6 minutes to read 19 pages. Think about everything that's said in the 19 pages, meaning consider it. And then, of course, if you did consider it and you find something of question, you would do some research on it. But evidently, they did all of this and gave it consideration and didn't have to do any research or something because they came back and just dismissed it.
Stamps of the order and the file stamp of the response indicate 2 separate days. That's all this court has to consider. And I don't know that we can know.
The order was 1 day. Upon the order being issued, the defendant put in a motion to dismiss the order. 6 minutes after they received that motion to dismiss, they dismissed, or that motion, they dismissed the motion. That's what they're saying. They don't care when the motion to issue or when the order was, the gag order was issued 1 day and then another day later. They're talking about when the petition or the motion to dismiss the gag order by the defendant was entered in the electronic system. And then 6 minutes later, a motion or it was dismissed by the judge. The same judge that arrested and released the predator, the child molester.
For sure, whether or not the court had access to the response before it was pushed through by the clerk. I can't speak to that. I know the response was before the court and it had the opportunity to consider it. So I think we can find an implicit finding here.
Let me ask you another question. When you're talking about discretion, and I think that's what just.
Whether you have the opportunity to consider it or not, 6 minutes. Yeah, you had 6 minutes to consider it, but is 6 minutes enough to consider it? So your assumption that they considered it is in error. These are the people that are playing this game with your minds.
Womack's getting to. You said the court exercised discretion. This order is substantially the same as an order that we vacated in 2020. So I guess how much discretion really was there? And it wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level.
I think
the gag order is a copy-paste document that has already been vacated by the very people that are sitting on this judge bench today. They recognized it. They said, wait a minute, we've already ruled on this. We've already ruled on this kind of broad scope gag order, and it was vacated. Watch what they go on to say.
It wasn't a carefully crafted order because it's obviously looks like a standard order that's being passed around either by prosecutors or by judges at the circuit court level.
I think you're dealing with who's making the petitioner here. The petition is the defendant, not the press, and we treat press cases differently.
No, you're not dealing with the one that that made the petition. You're dealing with everybody that allows it. Instead of taking the time to read it, read the motion to dismiss the gag order and give it proper consideration and do your proper research so you can properly dismiss the motion to deny the motion to dismiss, then you're just using templates. It's making their time, their legal time, worth more because then they don't have to do as much work. If they can pass around templates that the people will allow to work, then they'll just keep passing around these templates. While in the meantime, those of us that are fighting this system and we use template forms, they start calling it frivolous.
Than those of the defendant. And I think when you're looking at the order here and whether it's narrowly tailored, I would compare
But
the
we
categories.
vacated it completely. We didn't just vacate it as to the press. We completely vacated it.
In other words, they read the whole thing, considered the whole thing point for point, and vacated every last point in it. They vacated the entire gag order on the broad scope that was already presented in identical form.
And it had the same limits as to the defendant, the family, the friends, judicial officers, is exact, I mean, same.
Exact. It was identical.
Same language.
I'm not aware of that case, so I can't speak to that, and I apologize.
I'm not aware of that case, and I can't speak to that, and I apologize. Because this is, maybe it is the left hand doesn't know what the right hand's doing, because this is the state prosecuting assistant attorney general, whatever, at the state level. He's not at the county level. He's the one at the state level pushing the gag order as being valid. It's not. This goes to your First Amendment, Second Amendment, freedom of speech, freedom to express yourself, as well as the right to know. So when they're pushing this gag order, what they're doing is they're trying to prevent the defendant from being able to speak out about the actual facts of his own case. He's not allowing him to speak out. Also, it prevents him from being able to know what's in the case already because they gagged it, even from him. This is the utmost, highest form of corruption. And again, this is the same judge that let the predator, that let the child molester go. I hope you guys understand the importance of stepping up for your children. And when it comes to people like Aaron Spencer, killing your child's predator, that's something any man would do. I catch a predator with my daughter, I'd do the same thing. I'm sure you would as well. See, that's why they put the gag order out there. One statement. Just as I just said, any man would do the same thing. That one statement provided for a gag order because they don't want people to know the details of why he murdered him. They just want to present that he murdered him without any existential circumstances that led up to it. So pay attention. I'll be back at 8:30 with a review on Aaron Spencer's situation, gag order, release of the gag order, and let's get this shit show over with. The man's been in jail because he did something every other man would do. You guys know me. I love you, but I don't give a rat's ass whether you love me back. That's to say, I don't care if you hate me. I don't care if you don't respect me. That part's on you. So may God bless you and love you. We'll see you at 8:30. Bye now.